Let's start Indian polity. In Indian polity, mainly we have to read about Indian constitution. Then we have to also read the laws that are passed by the parliament and also various court judgment. So in Indian polity, we mainly have to read the Constitution of India, the laws that are passed by the parliament, and in some cases rules, notifications that are passed by the executive, and the judicial verdicts, the Supreme Court judgments that may include the old famous judgment or the judgment that is coming frequently in newspaper. So let's start with Constitution. So what is Constitution? Constitution is nothing but the document of people's faith and aspiration. So Constitution is the document of people's faith and aspirations. So what are the aspirations of the people of India? We want liberty, we want justice, we want equality. We want equality, we want justice in all fields, in political sphere, in economic sphere, in social sphere. And these aspirations are reflected in the Constitution. So Constitution is nothing but the document of people's faith and aspirations. Or we can define Constitution in another way. We can say that Constitution is the supreme law of the land which enjoys special legal sanctity. So Constitution is the supreme law of the land which enjoys special legal sanctity. So Constitution is the supreme law of the land which enjoys special legal sanctity. Now let's decode the term. What is the meaning? In a country, there is Constitution, then there are laws that are passed by the parliament, then there are rules or notifications or regulations that are passed by the executive, that is government. Now Constitution in this hierarchy sits at the top, and that is why Constitution is the supreme law of the land. In this hierarchy, Constitution sits at the top and all other things are below it. So Constitution is the supreme law of the land. It is not the ordinary law of the land. And what is the meaning when we say Constitution is the supreme law of the land which enjoys special legal sanctity? Let's assume Parliament passes a law which violates the provisions that are mentioned in the Constitution. Then that law will be declared null and void, that is unconstitutional. So any law, if that is passed by the Parliament, if that violates the provision of the Constitution, then that law passed by the Parliament will be declared null and void, that is unconstitutional. That means laws cannot violate the provision of the Constitution. Similarly, rules, notification, regulation that are passed by the executive also cannot violate the provisions mentioned in the Constitution. If they do so, then the laws will be declared unconstitutional, then those rules will be declared unconstitutional. Now let me give you an hypothetical example by which you will be able to understand the meaning. Let's assume tomorrow Parliament passes a law, and in that law it is being stated that teaching as a profession is declared illegal in India. Then let me tell you, this law will not stand the scrutiny of the judgment. So when the law is saying teaching is illegal in India, this will be struck down in court because it violates one provision under Article 19 of Indian Constitution. That is why this law will be declared as unconstitutional. Now let me give you a real example. You will understand it better. There was something called Section 66A of the IT Act. This was amended in 2008, and one of the provision was such that it was violating Article 19, Clause 1, Subclause A. That is freedom of speech and expression. That means a provision present in the Constitution. And judiciary, in a famous Shreya Singhal versus Union of India case, struck down this provision mentioned in Section 66A because this law passed by the Parliament was not in conformity with the provision of the Constitution, and hence this law was struck down. So when I say Constitution is the supreme law of the land which enjoys special legal sanctity, this is the meaning. There are three organs of a state, and these three organs are legislature, executive, and judiciary. Legislature is a body which passes the law. Executive implement those laws, and judiciary sits on the judgment and provides justice to the people of India, and also it checks the laws passed by the legislature, the action of the executive, whether those are constitutional or not. That means the laws passed by the Parliament, the act of the executive are checked by judiciary, and if the laws passed by the Parliament is not in conformity of the provisions of the Constitution, then judiciary will strike down that law. All these things are mentioned in Constitution. And when I say that the judiciary has the power to strike down the laws passed by the Parliament, this power to judiciary is also given by Constitution. That means it is the Constitution which is supreme, and Constitution is giving this power to judiciary. That means there is supremacy of the Constitution. Constitution is supreme. There are certain rights that is being given to the people of India, that is given by the government. So government is giving certain rights to the people, and also people has some duty towards the state. So people also has the duty towards the state. All these things are mentioned under Constitution. That means government, the state would provide certain rights to the people. People will also have to perform some duty towards the state. All these things, the relation between the state and its people, the government and its people, are mentioned in Constitution. So Constitution actually describes the basic principles of the state, the structure of the government, and the fundamental rights that are available with the citizen. All these things are mentioned under Constitution. So we can say that Constitution is the rule book. So Constitution is a document of people's faith and aspiration. It can be said that it is the supreme law of the land which enjoys special legal sanctity. Now let's read the different types of Constitution. And starting with a written and unwritten Constitution. So from the name itself, you can understand that the written Constitution, the provisions are written. But the important feature of written constitution is that yes, provisions are written, then the provisions are also codified in a single book or in a single document. So provisions are written and provisions are codified in a single document. What is the meaning? Let's take the example of India. Indian constitution is a written constitution. It is one of the lengthiest written constitution of the world. If you open the Indian constitution, in part 1 you will get union and its territory. Part 2 deals with citizenship. Part 3 deals with fundamental right. Part 4 deals with DPSP. So that means you can understand that provisions are not only written but they are codified in a single document. That means if you ask me to show the Indian constitution, I will show you a single book that this is the Indian constitution. That means provisions are written and those are codified in a single document. This is written constitution. Another example is USA, United States of America. And in unwritten constitution, it is not like that nothing is written. There are provisions which are written, but not all the provisions are written. And those which are written, they are not codified in a single document. Example is UK. So, if you ask me to show you the UK constitution, I cannot show a single book and tell you that this is the UK constitution, because the laws are scattered in different documents and those laws are not codified into a single document. That is unwritten constitution. One of the example is UK. And in unwritten constitution, hence customs, convention, that plays a very important role. Now the question arises, why this has not been codified? So one of the main reasons why this has not been codified, you can say, is the political culture. So political culture in UK is such that they didn't feel the need to codify it. So another classification is enacted constitution and evolved constitution. Let's understand the enacted constitution from the perspective of India. So in India, constitution was written by a body called Constituent Assembly. Representatives came, sit in Constituent Assembly, they made the constitution. So Constituent Assembly, the representatives came and they made the constitution for India. And the whole constitution came into force in 26 January 1950. Although it was adopted and it was completed in 26 November 1949, but large part it came into force in 26 January 1950. So it was made by a body called Constituent Assembly and it came into force on 26 January 1950. Indian Constitution is an enacted constitution. Another example you can take is the USA, United States of America. The 13 colonies came together at Philadelphia and they made the constitution for the United States of America, and that came into force in 1789. So this is enacted. So enacted constitution means there was a specific body which made the constitution. In case of India, it was Constituent Assembly, and the majority of the constitution, majority provisions of the constitution came into force in one single go, that is on 26 January 1950. Hence, Indian constitution is an enacted constitution. Now, in evolved constitution, we can say that there was no specific body like Constituent Assembly. That was the case in India. In evolved constitution, there was not a single body which made the constitution. That means the constitution has evolved over a period of time. You can take the example of UK. In UK, in 1215, Magna Carta came, which provided certain rights to the people of UK. Then over a period of time, more and more rights were given in different centuries. So you can see, in case of UK, there was not a specific body which where the representatives came and sit together and they made the constitution. It was not the case like this. So in UK, the constitutional provisions have evolved over a period of time. So this is evolved constitution. Now one question may come that in India, there are more than 100 plus constitutional amendments that have been done. So can we say that in a sense Indian constitution is also an evolved constitution? So the answer is no, because in India there was a specific body. The task of the body was to create the constitution of India for the people of India, and the majority of the provisions came in one single go, and hence Indian constitution is an enacted constitution. Another type of constitution, another classification is unitary constitution and federal constitution. In unitary constitution, all the powers are concentrated in one central body. All the powers means all the legislative power, all the executive power, all the administrative power are concentrated on a single central body. Now if you see in practical sense, if all the powers are concentrated in one single body, then it is difficult to run the country, and hence for the administrative convenience, there are, let's assume, different states or local bodies, and to them powers are delegated. That means there is a central authority who has all the powers, but for administrative convenience, this central authority has given state or local authorities some powers so that the country can be run efficiently. But in reality, all the power lies with central body, and at any moment it can take back the power that was given to the local bodies. That means the ultimate power is with the center, is with the central authority. Only because that the country has to be run in an efficient way, for the administrative convenience, some local bodies are created and they are given power, so that the country is run in an efficient way. Example of unitary constitution is UK. And when we say federal constitution, one of the best example is United States of America. Now, there are some features of federal constitution, and those features are existence of dual government, that means government at the center, government at different states. Then the distribution of powers between the center and the state. Then the constitution has to be a written constitution, because if the constitution is not a written constitution, then there is no meaning of the first two. Because when we are saying there should be two governments, one at the center and another one at the state, and between them the powers will be distributed, if those distributions are not written somewhere, then this can be violated anytime. So written constitution is one of the important features of federal constitution. Then another feature is the rigidity of the constitution. That means constitution has to be rigid, because let's assume there is a dual government, there is distribution of power, and the constitution is written. But what if the constitution can be amended very easily? So that is why one of the important feature is that rigidity of the constitution. Then another important feature is that there has to be a judiciary which is independent. So independent judiciary is extremely important, because suppose tomorrow there is a dispute between center and state. Center is alleging against state and state is alleging towards center. Then to resolve the dispute between the center and state, there has to be a judiciary who is independent, and it will resolve the problem. So these are the important features of a federal constitution. Now let's check whether Indian constitution is federal constitution or not. So let's check the first criteria. Yes, in India there is dual government, one at the center and other at the states. That means at different states there are different state governments and there is a central government as well. So there is dual government in India. Then whether in India there is distribution of power or not. Yes, if you see Schedule 7 of Indian Constitution, then you will see the union list, the state list and the concurrent list. That means the distribution of power is there. That means on which subject the center can make law, on which subject the state can make law. These are mentioned in Schedule 7 of Indian Constitution. Then written constitution. Yes, Indian Constitution is one of the lengthiest written constitution of the world. Then rigidity of the constitution. Rigidity of the constitution means center and state both will come together and amend the constitution. Yes, there are some provisions in Indian Constitution for which if those provisions are needed to be amended, then the consent of the states are required. Then the last, or you can say one of the important feature is that independent judiciary. Yes, in India the judiciary is independent. So it seems that Indian Constitution is federal. But let's wait. There is another side of the same story. Dual government and distribution of power both are true in case of India in normal circumstances. But what if there is Article 356, that is President's rule? Under Article 356, both these provisions are diluted. Then this condition, written constitution, yes, India has a written constitution, but if you compare it with US, in USA different states came together, made an agreement and they had written the constitution. So if you compare in that way, Indian Constitution is not written in the same way as it was written by USA. Then the rigidity of the constitution. In maximum case, if the constitutions are needed to be amended, the state legislature need not to be consulted. So we cannot say that the Indian Constitution is rigid. Then the independence of judiciary. Judges of the Supreme Court are appointed by the President, that means by central authority. So that means you can say that prima facie it seems that Indian Constitution is federal. But if you dig deep, then it seems that these features are somewhat diluted. That is why Indian Constitution is termed as quasi-federal.